Okay, so today we're going to talk about Oakland County DUI Defense, and here you can see my book, The 248 Club. It's a book I put together that talks about being charged with a DUI in Oakland County and all the judges, prosecutors, and everything you need to consider when going through this type of offense. So we're going to move through a presentation. We can talk about a lot about what's in my book. So the first thing, who am I? I was a former prosecutor in New York City, and I was a prosecutor in Oakland County. Was in all the district courts handling DUI cases on a regular basis. Went to the University of Michigan for law school. It says on the bottom there, dad of two. I have a daughter and a son. Very involved with hockey as a hockey coach. And as you see this book, I've written 9 books on criminal defense, different counties, different charges, just trying to share my knowledge with clients. So here, what will we cover in this presentation? We're going to look at the Oakland County courts, the judges. We're going to look at the timeline of a criminal case. We're going to talk about the art of a DUI defense. We're going to get into what that means. The 3 windows that we look into for any DUI case. The point of the case where you go deal or no deal, if it's something you want to resolve your case or move forward with the trial, what goes into that decision, and then for certain cases, the implied consent. Okay, so here's all the judges in the 6th Circuit Court. If you're charged with a DUI, that's a felony. Your case will begin in the district court, but will eventually go to the circuit court. And I list all the judges here. Not all these judges handle criminal law cases, but they rotate in and out. So any of these judges could theoretically handle a criminal case in circuit court. Here are the district courts, the 12 courts that make up Oakland County's courts. The 43rd Court, Hazel Park, Madison Heights, Ferndale. 44th handles Royal Oak and Berkeley. 45th, Huntington Woods, Oak Park, Pleasant Ridge. 46th, Southfield. You can see that the different district courts certainly have a number of cities, villages, townships, and each court, specifically if you're charged in one of those places, you would go to one of these district courts. So if you're viewing this, you probably know which court your case will be in. We're going to move next to the judges. So here are 31 judges and personalities. That's what I titled it. And the reason why I did that is because all these judges here, they're very different. They expect different things from cases. They handle cases differently. They're human. There are 31 different personalities that you can, when you go to court, you're going to interact with. Your attorney needs to know all 31 of these judges and their personalities, what makes them tick, how to get the best result in your case. So here are the 31 judges. Not going to go through all of them, but just to give you some perspective of when you're charged with a DUI in Oakland County, kind of what you need to consider with all these different judges. Next, the timeline of a criminal case. So in a DUI case, your first interaction is usually with the police department. It's you being pulled over for a traffic violation after an accident with a vehicle. You can have some interaction with a police officer. That police officer may or may not arrest you. They may do alcohol tests, field sobriety tests, write down any statements, any observations. So the police officer can issue you a ticket at that time, or they can hand it off to a prosecutor to further evaluate the case and make a decision on the charges. So when I was a prosecutor in the Warrants Division in Oakland County, the police department would send cases in. We'd have a big stack of files, and as a prosecutor, I'd go through them and determine what the charges were. So the prosecutor is ultimately the one that will charge the case. The police officer more gathers the evidence. If the case proceeds as a charge, it'll go to the court, where the judge will eventually proceed to interact with your case, and you'll go to the courthouse. So it goes from police, prosecutor to court. Now here's the art of proactive defense. So as you've been reading on my website and my books, all of my clients are proactive from day one, especially drunk driving clients. The first being the arrest. The client is arrested by the police. The second, once you're released from custody, that's the release, and then the tracking. So I call the art of proactive defense because most attorneys don't emphasize these steps. What can we learn from the arrest? the release, such as bond conditions. Is your driver's license valid? Can you leave the state? What sort of testing is in place? And the tracking. A lot of times with drunk driving cases, there's a gap between the arrest itself and actually going to court. So the tracking of the case. Do you have an active warrant? What is the status of the blood with the Michigan State Police? Kind of figuring out when your court case is going to be. And during this time, we're proactive. We put things into place weeks ahead of even going to court. Counseling, alcohol testing, AA meetings, education opportunities, community service. We think about which judge you have. Of those 31 judges listed in the previous slide, what sort of plan do we need, knowing that that judge is going to be handling your case? What plan can we put in place? So the art of proactive defense, I get into this a lot more in my book on the bottom of the screen, The Art of Proactive Criminal Defense. It's a lot of the information is available on my website. If you call me or email me, we'll kind of talk about this more in detail for your case itself. The next slide, the 3 windows of review. And here you can see Michigan DUI playbook. This is kind of the foundation of defenses, techniques, and strategies, and the 3 windows we look for your case. So ultimately, what's the first contact with the police? A police officer needs reasonable suspicion to pull your vehicle over or to have some sort of interaction with you. Usually it's a violation of the traffic code, or you're on the side of the road after an accident. The officer needs reasonable suspicion that you had violated the traffic code or to come to your aid for a traffic accident. The basis of the arrest, you need probable cause to arrest, meaning the officer needs to gather enough evidence via statements, observations of driving, field sobriety test, PBT test, eyewitness statements of other drivers, the basis of the arrest, the probable cause to arrest. Without the probable cause to arrest, an officer may still arrest you, but ultimately you may be able to challenge that arrest and potentially get evidence thrown out against you that's gathered after the arrest, such as a blood test or a data master test. The elements of the crimes, the final window we look at for a drunk driving case, pretty simple. Were you driving a vehicle? Is there evidence supporting that element of the offense? And is there some sort of blood test or breath test or officer observations that could satisfy the element of intoxicated, impaired, or potentially super drunk? The most common combination of elements of a crime, I'd say 98% of cases, is a police officer pulls you over, he sees you're driving, eventually you're arrested, a test is performed, and the prosecutor could present evidence that you're at 0.08 or above. Those are the elements of the crime. So on its face, seems like straightforward case, have my evidence, but as we get more into things, we'll talk about the defense's techniques and strategies around that, including the proactive approach. The next slide, deal or no deal. Now, we got to the slide pretty quickly, but when you have a criminal case, it takes a comprehensive approach to figuring out what's the best approach for you. But ultimately, at the end of the case, you need to consider what is the best outcome for you. What are your goals? In making this decision in Oakland County, we look at the traffic stop, accident to driving, field sobriety test, any statements you make, officer observations, the knowledge that they have about your case, and any chemical tests. Also, prior record, driving record, your career and family, and your goals in life. So a lot of things go into making a decision about your case. For all cases that I handle, we handle the case both inside and outside the courtroom, meaning that not only are we looking for potential motions to file, defenses at trial, but we're building a foundation prior to even making this decision of being proactive in order to create leverage for yourself, in this case, in order to get the best record. Ultimately, what you want for a DUI case is, what are your goals? Can we achieve those goals? And can we limit the risk? Can we move forward with limited impact in your life? And most of the time for drunk driving cases, even some second offenses, even some third offenses, there is a very manageable outcome that we can lock in by working hard and being proactive. Now, in certain cases, if you refuse a test, a chemical test, the implied consent law kicks in. And there's a lot of information on my website about this implied consent in Oakland County, the 4 factors, what are some creative solutions, and the ultimate at the end, a hardship license. You may need to go to the circuit court in order to achieve that. If you have a case where an officer is indicating that you refused a chemical test, you'll have 14 days to appeal that. You should use an attorney for that. An attorney will be able to guide you in how's the best way to keep your driver's license, or if your license is taken away, how to get back on the road in various different ways. So if you're charged with a drunk driving case in Oakland County, I encourage you to reach out to me. We'll go into more detail about the charge itself, your goals, and kind of see what we can figure out.